For my review, I looked at New York State Rifle and Pistol Association Incorporated v. Bruen, the case in front of the Supreme Court currently. We're lucky enough to have live oral arguments available. And so that allows us to differentiate a lot of the questions. Basically, the facts of this case are as follows. The state of New York requires a person to show a special need for self-protection to receive an unrestricted license to carry a concealed firearm outside of the home. Robert Nash and Brandon Koch, two residents of New York State, challenged the law after New York rejected their concealed carry applications based on their failure to show proper cause. District Court dismissed their claims, and the U.S. Court of Appeals for the Second Circuit affirmed. The main position of this brief is that the New York State operates as a may issue state rather than a shall issue state. The differences between these two terms are the keystone of the entire brief. Namely, states that operate as a may issue jurisdiction are not required by any statutory regulation to issue a requested permit in situations where the applicant may have completed all listed requirements. If that applicant fails a case-by-case judgment based on specifically selected or elected, or no, just selected licensing officers. The licensing officers are selected on a county by county basis. And this differs from states with a shall issue statute. The shall issue statute requires that if an applicant meets the base requirements, that the state is required to issue the permit. When applying for carry states that operate as a may issue state, they'll outline a list of requirements and parameters that a person may obtain a permit to either conceal, carry, or even purchase. These parameters are widely agreed on, such as mental stability, felony status, and even some circumstances or good moral character, which has its own discretionary abuse potentiality. These limitations are also placed on histories of people with histories of domestic violence. Some states require specific training to safely handle a firearm, as well as specific instruction on force de-escalation. Now, these parameters are widely accepted and generally are of little concern to the majority of citizens. So the issue that the petitioner is bringing to the Supreme Court of the United States is that in a state where an applicant may have met all of the requirements, they may still be denied their constitutional right for not meeting the standard of a letter of necessity, which is specific to New York State's may issue. And this letter of necessity found in the application gives the legal justification for failure to show good cause. Now, the question posed by the petitioner is that does New York's law requiring that applicants for unrestricted concealed carry licenses demonstrate a specific need for self-defense violate the Second Amendment? Generally, the legal framework for this is based mostly in Heller, which was a court decision in 2007. In the Heller case, the Supreme Court ruled that the Second Amendment protects our right for not only the keeping and bearing of arms, but also the operability of those arms as a means for self-defense inside the home. Now, where this differs, and Justice Kagan and Sotomayor bring this up in oral arguments, where this differs is that this, the Heller case specifically limits the application of the law to people inside their home. Justice Scalia in his notes lists that the home is the greatest area in which we would need or legally be protected for self-defense. So while this on its face appears to be a Second Amendment expansion, case. I think that also it is a 14th Amendment case, strongly because I think the biggest limiting factor is that in may issue states, it allows for greater ambiguity and a more broad tailoring to those distinguished as not having a good cause exception to the law. The good cause exception and the specific tailoring definitely needs to be more narrowly tailored to create specific situations that would limit somebody's use of the rights outlined in the Bill of Rights, rather than trying to find a good cause exception to take part in the rights. Throughout this case, having the oral arguments, it's good to go over some of the portions that questions like, does atypicality denote prejudice? I think that this should definitely be a pillar of the petitioner's argument. Having a statute applied differently based on your location or living arrangements is prejudicial and inherently unconstitutional. Atypicality, when its very essence be the difficult, would be more difficult in a denser populated atmosphere. This also seems to be counterintuitive. Chief Justice Roberts also questioned Underwood, the representative of the state, on the likelihood of being robbed in the woods, bringing this back to a self-defense issue. As we come together, I think that this is going to be a tightly decided 5-4 in favor of the petitioner. And as it goes forward, it may alter New York's approach to issuing permits, in that it may lose its capability to be a may issue state. Why I think this will be impactful as far as case law is that once this is decided on the federal level and made as a Supreme Court decision, it will remove a portion of the state's rights to be able to designate those who it seems or who it determines ineligible, which is a question of too much inference. I think that Justice Sotomayor brings up this point in asking whether a state has the right to determine who is eligible. As we go on, I think in conclusion, this will go to a 5-4 decision in favor of the petitioner. And I think that there will be a lot brought in, not only on expansion of Scalia's original comments on the Second Amendment in the Heller case, but also expand the aspects of the 14th Amendment as it comes to prejudicial actions while issuing permits. Thank you.